Okay, well, let's now turn to the topic of board responsibilities. What defines their board responsibilities? I think of things I've heard in trade organizations. CAI talks about protecting, maintaining, and enhancing the assets of the association. Um, you spoke about the business judgment rule, kind of how their decisions are going to be measured, but what is their objective? What are they trying to accomplish?
Well, the responsibilities of the board are going to be found in two places. It's going to be found in the governing documents, and it's going to be found in state laws, and also case law, and in occasionally some federal law, but it's mostly state cases and state statutes. So those three areas will define what the responsibilities of directors are. But the first and foremost responsibility of a director of an association is to maintain the common areas. That's why associations are created to begin with. When you have common areas, somebody has to take care of them. And so you create an association. Association elects a board of directors. Board of directors sets a budget. Budget is for the purpose of maintaining the common areas, getting insurance, insuring the common areas, and then a lot of other things that go along with it. But that's their primary responsibility. And as long as they're doing that, and part of that maintenance thing is the reserves, because there's the day-to-day maintenance, and then there are long-term big ticket items. And
Yeah, I was going to ask about that conflict between short-term and long-term thinking.
and they have to do both. So setting a budget for an operational budget, day-to-day kinds of things, and then the longer term, contributing into reserve and getting a good reserve study, and then following it is critically important. And I know that one of the studies that you did showed that there's a correlation between healthy reserves and property values. And a good, strong, healthy reserves, a financially stable association that's well maintained, has more value than an association that does not. And that's common sense. And so if they're doing that, there's a balancing act on that boards are constantly faced with, and that is, okay, do they need to raise the dues in order to, keep current with inflation, to maintain the common areas, to properly fund the reserves? Yes, they do. Okay, but what if that, does that mean that they're going to then be outside the market on assessments? Which is an important element. I've heard that so many times from boards. Well, we want to stay within market. We don't want to be above market. It's okay to be a little bit above market. It's okay to be right on the money on market, or maybe a little bit below. But you don't want to be an outlier that is double the market on your assessments, your monthly assessments, or half the market on your assessments. I don't know of very many that are double the market. That almost never happens.
Yeah.
But certainly seeing them that are half the market, and I've actually had boards tell me that's their intention, is if they are way below market on their monthly assessments, their units will be worth more. People will pay more for them. Well, I don't buy into that, because the only way that they can do that is that means that they have to defer maintenance and not properly fund the reserves.
Which
And
is what happened at Champlain Towers.
yes, and so that will catch up with them. And so at some point, there's going to be serious consequences for that decision.
Yeah, I think there's some of those that are just patently obvious. If you are a prospective buyer going in and it has a very attractive low monthly assessment structure, I bet you'll probably see it with the worn carpet, with paint that's peeling or chipping, if you go at night to look at the property, I bet you'll see it pretty dark because they're not even replacing light bulbs. There's a lot of things that are just plain visible. And when I think of a home, it has a lot more to do with what I'm going to enjoy and live in rather than what is the monthly assessment that is variable. The next board can change it. And you have every expectation that if it's below market, there may be a good reason for it. It may come back to bite me.
Yeah, and I agree with you. I think that the deferring the maintenance actually drives down property values.
Yeah.
and people come in and look at it, they go, "Ooh, it's kind of dirty and run down, and I don't
Yeah.
want to live
Well,
here."
we've heard of
And
curb appeal for so many years, and
right,
curb appeal is real.
yeah, and then the other consequence is that you'll have investors who'll come swooping in because stuff is cheap, it's below market, and they put renters in there,
Ah,
and they don't care about maintaining the property. They just want, an investment that they can put
positive
renters in,
cash flow.
right, get positive cash flow. So, and that further spirals down, the association and the value of units in there.
Yeah. Well, you mentioned one word, and I circled it down here. I'm taking notes while you're speaking. You spoke about common sense. The board is responsible to uphold the governing documents, state law, case law. What about common sense? Is there any measure or measure of common sense or an expectation an owner should have that their board is
Well,
operating in common sense?
yeah, the owners certainly have an expectation that the board is following common sense, and by and large, most of them do. Can they make mistakes? Sure, they do. But by and large, they're trying to do the right thing, and they're using common sense. It's where you occasionally get a board like the one I've been talking about, where they decide that they want to not spend any money at all. In fact, it's their job to spend money, and they're supposed to raise it and spend it, and on the items that are budgeted for it. And so what they'll do is they'll not seek proper management. They'll not seek legal advice. They won't, seek. They just cut corners in a lot of ways where they shouldn't be cutting corners. In addition to deferring maintenance.
That comes back to what you were talking about. Their job is to act in the best interest of the association. That's one of the
Right.
three pillars, business judgment rule.
Yeah, and the not seeking proper advice is the third element, which is reasonable inquiry. And if they're not asking questions or not seeking advice where they should be seeking it, they're not, and getting a proper reserve study, seeking legal advice. And I'm not trying to promote, hire lawyers for everything, but there's no way that they can know what the laws are and what their, changes, in case law and information that they need to be doing without seeking legal advice. And do you want to call the lawyer every 10 minutes? No. But there are times when you need to pick up the phone and ask, okay, what do we do about this? Here's the situation we're facing. And that's the reasonable inquiry part.
Yeah.
And
Because you're a board member, you're not an attorney, and you need
right,
help to make the right decision. And then we go back to in the best interest of the association.
right. And the other problem that we see where sometimes common sense, um, you've got some board members that are trying to use common sense, trying to do the right thing, and then you get a rogue board member who is incredibly disruptive, who is really off on different, going down rabbit holes, um, and causing a lot of grief for the board. And it can be very discouraging for good board members to have a rogue director being so disruptive. And it may be that they have a private agenda. They don't want the assessments to be raised. They're going to fight tooth and nail to keep them, which means no reserve contributions, defer on maintenance, and it's just very difficult. Boards struggle with rogue directors, and it not you can have a director that simply disagrees, has a different idea and how things will be done, and that's okay. And but when it comes to a vote, and if they're in the minority, they lose on the vote. They express their opinion, and if they want in the minutes, it can be in the minutes. But at the end of the day, majority rules, and they need to then get on board with wherever that's going, and move on to the next issue. But it's the rogue directors that are purposely being incredibly disruptive and fighting common sense and attacking fellow directors. That sometimes boards, this is where legal counsel comes in to assist, and maybe it takes a strong letter from legal counsel to that one director to cease and desist. It may require the censure of that director so that there is a a record in the minutes. The board disagrees with what this director is doing. And this also helps them in protecting them from potential liability for what that director is doing. And we've worked with a lot of boards over the years where we've encouraged them to censure a director, otherwise they may be facing potential liability for what that director is doing. And then finally, it may be that you need to form an executive committee of directors minus the problem director, the road director, so that business could get done, on dealing with executive session kinds of things where confidentiality is required, and one director is releasing, private information, confidential information to the world at large, and things that are protected by statute. So we've had to do that in order to protect the association and allow it to move forward.